Good afternoon, everybody. I'm retired Judge Carrie Katz, a neutral at signature resolution. Drawing on my experience as a construction litigator and civil trial judge, I am now serve as a mediator, arbitrator, and special master in construction-related matters. Today, I'm joined by the always insightful and highly regarded construction attorney, Casey Garcia. Casey, tell us about yourself.
Yeah, hi everyone. I'm a partner with BBG Construction Laws, also known as Beltert Bankern and Gannell. I'm based in Irvine, California. I'm going on my 16th year as a practicing construction law attorney. I've only ever practiced construction law and only in Southern California, so I'm very familiar with our California construction law issues. My practice has evolved over the years, primarily representing only general contractors, but I do have some experience in other realms of construction. I focus in litigation, but I also fill some project support roles for our clients on very large projects as well. I do also have a bit of an insider's perspective because I did serve in-house for a large general contractor for some time before deciding I wanted to go back to private practice. And I think COVID-19 probably also helped with that decision. But I'm so excited to join you guys here today and to join Judge Katz for this discussion.
So everybody, have you ever had a construction case where the efficient solution ended up making the case much more complicated than anticipated? Casey, what do you think about that?
Unfortunately, yes, a lot. And honestly, the more we try to solve a particular problem, the more problems it seems to we often create. That's probably one of the reasons why us lawyers get such a bad rap, right? We solve problems and create two more in the process.
Today, we are going to provide strategies to deal with these issues. Each case is different, and these coordination issues are not going away. In fact, as Casey said, the more we try to solve them, the more complicated they become. We're going to provide you with potential ways to minimize the issues arising from multiple form proceedings in a single project. Let me start with a quick story, which kind of got me in this realm of why I'm talking about this with you and Casey. This example illustrates that construction lawyers are seeing up and down, at least in the state of California. I had a construction place where I asked the attorney a very simple question. So, where is the dispute being resolved? I thought that was like an easy answer. And I got the answer. The attorney told me the delay claim was in arbitration, the default claim was in court, and the subs were thinking about hiring a judicial reference. And I remember thinking, this isn't dispute resolution. This is a multi-forum chaos with a calendar invite no one wants to accept. But instead of one case moving forward, there are now multiple tracks, multiple forums, multiple strategies, all happening at the same time. And the result is not efficiency. This is exactly what we're going to talk to you about in this presentation. Parallel proceedings, inconsistent risk, and a lot more cost. Casey, have you experienced this?
Yeah, more often than I'd like to admit, unfortunately. And I'm going to give you a hypothetical example because my real world example that is similar to these facts is still playing out right now. So while some of them are taken from a real world situation, others are not. Just giving you that bit. So this kind of pulls from scenarios many of us have probably seen in our practice. We represented a general contractor on a large scale construction project, and towards the end of the job, the owner withheld a substantial sum of money. Let's call it somewhere in the eight-figure range. And they claimed it was based on alleged defects and delay claims. From the contractor's perspective, there was little support for those claims. The contractor had not been presented with meaningful evidence of defective work, and to the extent that there were delays, the contractor attributed those to design issues and owner-driven changes during critical phases of the project. But as you all know, the contractor couldn't simply absorb that kind of financial hit while continuing to pay downstream parties and separately litigate with the owner. So payments to a number of subcontractors were withheld, which led to mechanics liens and multiple foreclosure actions being filed in Superior Court. The first issue we had to address was that the prime contract and the subcontracts pointed to different forums. So the prime contract required arbitration with one provider, maybe JAMS, while the subcontracts pointed to a different form altogether. That mismatch alone created immediate coordination challenges that we had to overcome. Another issue was procedural layering. So the prime contract required completion of a multi-step pre-arbitration process, selection of a neutral decision maker, exchange of position papers, and then a non-binding decision before mediation could even occur. And because the dispute involved delay issues, that also meant engaging experts and performing a delay analysis at a very early stage. That process alone was going to take several months before any meaningful settlement discussions could begin. At the same time, the subcontracts effectively required the subcontractors to pause their claims while the upstream dispute was being addressed. Some were willing to do that, but others weren't, particularly smaller subcontractors facing significant withheld balances who needed to move their claims forward. So what we ended up with was a situation where multiple processes were moving or trying to move at the same time, a structured pre-arbitration process upstream, anticipated mediation, and active court proceedings downstream that required motion practice to stay or coordinate. And after all of that, after significant time and cost, very little progress had been made toward actually resolving the dispute. And that's really the point. The system didn't break down because of the merits. It broke down because the process itself became the obstacle. So when dispute resolution becomes more complicated than the dispute, you're not really managing risk, you're compounding it. And that's the tension we're here to talk about today, how to bring some structure and strategy back into a process that, if left unchecked, can create more problems than it solves.
So today we're going to talk about this tension, the theory, and the reality. I'm going to start with just the title page. Next slide. Casey described the problem in detail, so I'm going to move on to the agenda. We're going to have an overview of multi-track disputes in construction. We're going to talk about that. We already started with a hypothetical. We're going to give you some legal framework and discuss the risks. We're going to talk about some existing statutory solutions, namely CCP 128 1.2. We're going to talk about the mediation arbitration model and provide practical strategies for attorneys. If we have time, we'll have some questions and answers at the end. Next slide. As Casey described to you, construction projects involve multiple contracts and parties. Each contract may have different dispute resolution clauses. As Casey had indicated, there was one that was in court. We've had one where there's an arbitration, and I've had one where court, arbitration, and special master were all involved in one dispute. The risks that we see are parallel litigation, arbitration, litigation, mediation running all at the same time. And it can result in inconsistent rulings and increased costs.
So, yeah, and I'll jump in. Sorry, I got disconnected again. I'll just
We're at the problem here. I think we described it. I think we should move on to the next slide.
Can you hear me, by the way?
Yes, we can.
Okay. Yeah, just making sure. So yeah, so as I highlighted in my prior hypothetical example, when we are representing these general contractors on these large.
All right. Poor Casey we're having problems with Casey, you're coming in and out.
Oh, I'm so frustrated. I'm going to turn off my camera, but I have no option to do that right now. I apologize.
Okay, so while you work on that, I'm gonna talk about the different processes equal conflict. Just generally, folks, the conflict arises in many ways, but there is discovery conflicts. This slows the process down and can lead to inconsistent verdicts. The advantages of arbitration is limited discovery, but if you have litigation on top of arbitration, you no longer have the advantage of limited discovery and arbitration. You have mediation on top of that, which is non-binding. The good news is it's confidential, flexible, and you can work on different things, such as having a mediation which is just process driven, trying to figure out which goes first, how we go first. Do we do ARB first? Do we go to the court first? What tool do we use in what manner? And we'll talk about this later, but if you can get everybody in the same room and come to agreement, and that's an if, in a mediation as to the process, that's a good way to go. I submit without coordination, parties will end up covering bases in all three at once, which is going to cost everybody a lot of time and money. We're going to skip slide 5. Casey, can you hear us? It's like Casey's frozen. Just a simple example so everybody, okay, we had a simple example. We're going to go on to the simple example so everybody has it. Contract A is mediation first and then arbitration. Contract B is litigation only. That is not unusual. You could have an owner and a prime agree to mediation and then arbitration. Meanwhile, you have the contractor and the subs agreeing to litigation only. When the downstream subcontractors are pulled into dispute and are not bound by the arbitration clause, it's almost impossible to get them into arbitration unless they agree. The attorneys must manage multiple tracks all at the same time. Let's move to the next slide. Casey, can you hear us? We've lost Casey. Next slide. All right, folks, one of the best tools I've seen work, and as a trial judge, I have seen it work. I think if Casey was here, she'd tell you that not all judges agree on how to apply this code section. But generally, it allows courts just discretion when there's conflicting rulings on common facts and that may occur. For example, where a party to an arbitration agreement is in litigation, arising out of related transactions, a court has several options under this code section. The court can delay the arbitration to determine other issues not subject to the arbitration and which may make arbitration unnecessary, or the court, where a party is in litigation and arbitration is pending, the court may refuse to enforce the arbitration clause and order joinder all in a single matter, which really would solve your problem. And I'm sure we're having problems with Casey, but Casey will tell you that she's filed motions and the judges don't always agree with that. And we can talk about ways to deal with that. But for now, let me keep going on what the judge can do. Again, a judge may refuse to enforce an arbitration clause and order joinder of all parties in a single court action. A court can order intervention or joinder as to all or certain issues. A court can order arbitration among the parties who have agreed to arbitrate and stay the pending action pending the outcome of litigation. That is what I've been involved in. And it seems to solve some of the problems. And lastly, and this is probably the best option. However, I don't know if Casey can hear us, but Casey has indicated this is the least one used, but that is the court may stay the arbitration completely pending the outcome of the court action. Casey, what do you think about this 128.1.2 statute? Helpful?
It depends on what judge is using it. But I apologize for my technical difficulties. I'm going to keep my camera off in hopes that it eliminates my problems, but we'll see. And I know I missed some points that I want to make sure I comment on, so I apologize if I backtrack a little bit, but I do want to make some comments. We can keep it on the slide as well. So one of the things I wanted to talk about was I had in a particular case, I had a writ that I had to seek, and that was to stop one action from going forward. So as I mentioned, we had a vast majority of subcontractors agree to stay their cases pending arbitration with my earlier hypothetical example. But it was no issue to them because that's what their subcontract required. But one subcontractor in particular did refuse to stay their case. They argued that because a mediation involving them had not yet taken place, they had no obligation to stay their case and could proceed with discovery in Superior Court. At the same time, we as the general contractor were in the middle of a multi-step upstream process with the owner. We had limited information about the specific claims tied to that subcontractor's work at the time because the owner had only provided high-level allegations at that stage. So a mediation with that subcontractor at that point would have been purely procedural, like a check the box exercise. But we scheduled it anyway to try to move things forward. The problem was that the court focused on the fact that the mediation had not yet occurred, and that alone was enough for the court to deny our motion to compel arbitration and allow the subcontractor to proceed with discovery in the Superior Court action. The court even went a step further and limited our ability to object to the discovery on arbitrability grounds and required us to wait until after the mediation to refile our motion to compel arbitration under 1281.2. And that was in a contract that clearly required arbitration. There was literally no path to litigation at all, but because our contract required that we mediate before we arbitrate, the court just hung its hat on that strict interpretation of that provision, which just created a procedural mess for the rest of the cases. So we ended up having to seek a writ, and fortunately, we were successful. But had that gone the other way, we would have had one subcontractor actively litigating in court while all the others were stayed, despite identical dispute resolution provisions. I also want to highlight the cost of that effort. That writ process alone was roughly a $50,000 endeavor. And that's $50,000 just to figure out where the fight is going to happen, not actually fight it out. Nothing in that process addressed the merits. Nothing moved the parties closer to a resolution. It just determined who gets to spend the money first. It was just a procedural issue. And that's the problem we keep running into.
Casey, Casey and I have spoken about this, and my advice as a trial judge, former trial judge, is that you do your best, and I'm sure Casey did, but judges have a lot on their plate. Some of them have 1,500 cases. Whatever you can do to help the judge make the right decision, give them all the facts, explain the costs, explain the duplicative efforts, and hopefully they will listen. And I think that explaining the costs, the extra efforts is going to go a long way in getting the orders that you need.
Yeah, I would also say, I know that you've gone over this, but as you talked about, I'm sure in the previous slide, in litigation, you have obviously broad discovery rights, which
Yeah.
can be helpful, but that often makes cases move really slowly. And I mean, right now in courtrooms recently, I'm hearing trial dates offered in late 2027, even early 2028. And in litigation, as you mentioned, I'm sure you don't always control your decision makers. Judges come from various different backgrounds, and you can end up with a complex construction case in front of someone who doesn't regularly deal with those issues, or a jury that's not focused on the technical merits. It just kind of could look at someone and be like, I like that attorney better, or I like that client better, as opposed to what they're actually saying. So, in litigation, when we end up there, you know, it can be inherently risky. And then, obviously we definitely as construction lawyers prefer arbitration for our cases because we can, discovery is more limited and the process can be more streamlined, and you're typically in front of a decision maker with relevant experience. So and also there's even a lower likelihood of the outcome being challenged after the fact. And practically speaking, arbitration tends to be more adaptable right now, especially right now. It can incorporate new technologies and more efficient procedures without the same level of institutional friction you see in court. That flexibility has become increasingly important in complex construction disputes, and we're trying to use it to get the parties from point A to point B in a relatively quicker and more efficient and less cost prohibitive way. Um,
As
but
we discussed, Casey, there are probably lawyers right now who do not like arbitration, construction
no,
lawyers who believe that having a jury decide a case is the only way to go. I've heard it
I
both
would.
ways. I've been a trial judge and I've already also been an arbitrator. You're 100% right. An arbitrator has a lot more flexibility to make decisions and adapt to the needs of the parties than a judge.
Yeah.
But you lose the jury. And I know there are a lot of folks out there that want to try their case in front of a jury. It's just a balancing act, and you have to decide which works best for your client.
Well, and just like you said, a judge may have 1,500 cases that they're dealing with, and an arbitrator is not like, I mean, that's where I've seen the struggle. I've tried to tell judges, like, hey, this is the real issue behind our case. This is what's going on, and this is why your decision is going to impact me here, here, and here. And honestly, there's times where I'm like, this judge just wants to get to the next case, doesn't care what I have to say. They're literally just moving from, and maybe that's a bad example, and I don't want to, you know, say that all judges are the same because I don't think you would have been. I never was in front of you, so I can't, I can't make any comments about that. But yeah, I mean, that was what I felt like in that one particular case where we had to seek a writ was that no matter how I tried to explain it, I just felt like I was not being heard. So that's one
You were
reason
heard on the writ. Good job.
I was heard on the writ. Yeah.
That's right. Sometimes it takes that writ. But um, let's talk about some recent trends, which is the next slide. There we go. All right, folks, there are some recent trends, not particularly, well, they apply to construction, but they're really out of the construction realm. There's the Ford motor warranty cases. And in those cases, the California Supreme Court prevented vehicle manufacturers from forcing consumers into arbitration when when they didn't sign the contract or there was not privity. Um, and there are some other recent cases that seem to they come out of the Disney type of cases, Disneyland ticket type of buying cases, and it's clear that the courts are reluctant to compel arbitration without contractual privity. So when you are entering in these contracts, you have the GC and the prime saying, great, let's go to arbitration. And Casey, is all happy. We got arbitration here. But the contract with the subs or the no contract says, go to court. And you can't really compel the subcontractors to join the arbitration. The one thing you can do, and I don't know if Casey's had experiences this, is ask them if they want to join the arbitration. Talk to them about maybe mitigating the costs because subs have obviously less the money to provide for the litigation. But you can go to a mediation and agree, okay, this is a process mediation. We're going to agree to the subs are going to go into court. Casey, any comments on that?
Yeah, well, I mean, I'm going to definitely come at this from where I represent large general contractors. I mean, we're pretty good about making sure our clients are pretty good about making sure that the dispute resolution provisions in our prime contract are flowed down into our subcontracts. Typically, where we see significant issues are our subcontracts or our sub supplier contracts because some of those, our sub will enter into a credit agreement with, a concrete company that supplies concrete or electrical equipment, and they enter into that agreement that's not project specific and it applies to every job that they do. And in those situations, they have an incorporated dispute resolution provision. So when I don't pay the sub and the sub doesn't pay that supplier, the supplier is going to say, I don't have an arbitration provision or a mediation provision in my contract, my credit agreement. So that's typically where we see those come up. Luckily for me, most of the time the supplier contracts are small dollar figures that we can resolve to keep all of the parties in the same forum. But yeah, generally focusing on making sure that your subcontracts include the same or coordinated um, dispute resolution procedures so that you're thinking about the whole project holistically.
And generally, those contracts I didn't see when I was in court as a mediator. Once in a while, I see them, but the ones I saw in court were ones where they're not the big
Yeah.
contractors or smaller contractors, and they didn't check the downstream, and they have problems getting everybody in the same venue at the same time.
Yeah.
Why don't we try this other benefit another way, in addition to 128 1.2, where you go into the court and try to get the court to help you. There's another benefit of what we call the mediation arbitration model. I've been referring to it throughout the presentation. I want to go to the next slide, and Casey's yours.
Yeah, so I mean, there's a different ways to look at this. So, typically our contracts will include a mediation first requirement. I'm taking recently I've decided that I don't love those that much. But as I've told Judge Katz, um, but I think they're usable, they're helpful in some circumstances. So there's two different scenarios I think we're really kind of talking about here. And one is just you mediate first as a requirement or a precondition to arbitration. So in that situation, the parties would attempt to participate in a non-binding global mediation first, followed by arbitration. Um, that would encourage resolution while also preserving your arbitration rights. I mean, if you use AAA, sometimes I know they have a situation where you can actually file your arbitration demand, and then you stay that demand pending outcome of a mediation that's all conjointly done at the same, I'm sure, signature resolution. I'm sure any of those ADR providers have something similar to that. So you're not just delaying the inevitable arbitration filing, but you're kind of doing it, there's a process to it. And then there's another item here that I think is important to note. I haven't actually done this before, but I theoretically see the benefit of having a mediator that handles both phases. So you serve as a mediator for the initial mediation, and then if the parties agree to it, then serve as the subsequent arbitrator of the dispute. So by default, you're almost waiving all that settlement privilege conversation and positioning that you had in your mediation. And I'm sure some clients would be hesitant to do that, but as we'll talk here, I'm sure that there are some benefits to that, especially in how my clients have recently been approaching mediation and the downsides of what happens when the other side doesn't approach it the same way. But yeah, so there are these multiple models that you can proceed, the mediation through arbitration models.
Right, and one way to do this is have the mediator handle both. I understand the pros and cons of it. We could talk about that for a long time here today, but putting that aside, you could have a mediator and an arbitrator. There's no reason why they can't talk about process. The two different dispute resolution officers talk about the process, it's confidential, and try to work things out. Or you can have one person do both. I think both will work depending on the needs of your client and what your client really wants to do. Something you'd have to really explain to them and have some waivers along the way. So let's move to the next slide. So Casey, you're going to tell me what the benefits of the meet arbitration are.
Yeah, um, so assuming you're all on the same page, the mediation arbitration model will really start to show its value. So first, it reduces duplication. Instead of telling the same story in multiple forums, court, arbitration, mediation, you're consolidating that effort into a more unified process. That alone can significantly reduce time and cost. Second, it creates a real opportunity for early resolution because everyone is at the table across contracts and across roles. You're not just solving one piece of the dispute, you're addressing the project as a whole. Another key benefit is continuity. And this is in this particular situation where you're using the same mediator, arbitrator, or some kind of combination of the two. The mediator, if you later serve as an arbitrator, would already understand the facts and the players and the dynamics. You're not starting from scratch every time you move to the next phase. That familiarity can really make the process more efficient, but also more accountable because the reality is that the parties are far less likely to play games in that scenario. You can't come into mediation taking an extreme or performative position if you know you may have to carry that same position in front of the same decision maker in arbitration. So it forces a level of discipline and credibility that you don't always see in traditional mediation because your audience doesn't change and that may change the behavior. It also changes how information is shared. So instead of holding everything back for strategic reasons, parties may be more thoughtful in what they present, because they know it's not a one-day exercise, it's part of a continuum. And in my experience, that leads to more meaningful negotiations, not necessarily immediate settlement, but more realistic positions and fewer theatrics and maybe a clearer path forward if the case doesn't proceed. So continuity doesn't just save time, it improves the quality of the process itself. And maybe most importantly, it also helps unify the parties who otherwise might not be aligned. In construction dispute, that's often half the battle. You've got owners, general contractors, and subcontractors all operating under different contracts and different pressures. So this model creates a structure to bring groups into a single coordinated conversation. Again, it's not perfect, and we'll talk about the drawbacks next, but when it works, it could take what would otherwise be a fragmented multi-track mess into something much more manageable.
That's been my experience too, that if you meet, do the mediation, then move into the arbitration later, just seems to make things a lot smoother. You get everybody on the same page and can stop the multiple venues. There probably may or may not be somebody in the Superior Court, but hopefully by that point, it's what's left is the mechanics lanes that you can deal with at the end. All right, why don't we do the next slide? This is the drawbacks. Casey.
Potential drawbacks. Well, I guess the various different drawbacks to that is that it requires a party's agreement. And there's, like I said before, some fear that the mediator bias may enter into the arbitration phase. I'll say this. One thing I've really struggled with recently is I have some clients that have really taken a different approach to mediation where they are essentially almost like summary judgment, mini trial typing their mediation. They're doing all the investigation and coming to mediation armed with a ton of facts, right? We have documentation and support for every claim we're making. We're really entering it as almost like we're proving our case to the other side. And that's just those particular clients, that's how they like to approach mediation. The problem with that is that what has happened is not every side of the of the dispute does the exact same thing. So maybe the owner or a subcontractor comes in and all they were coming in to do was really, state their case and make an offer. And now all that's happened is we've given the other side a ton of free discovery and we've received zero from them. And then they're frustrated. I mean, the other side's like, wow, I have homework to do. Now I need to go do some discovery and tries to start building their case. And it didn't get settled in the mediation. And now we're just at a really weird spot where we've spent a ton of money prepping for a mediation and the other side has not, and we didn't get a settlement, and now we're going full force into arbitration. So, I like the idea of the mediator that then serves as the arbitrator because they're going to see that process play out. And they're not going to, because if that process played out before a mediator and then you start your arbitration, the arbitrator has no idea what just occurred through that whole beginning phase of the process, and you're basically back at square one. But from the other side's perspective, they would be fearful that that mediator would then enter into the arbitration with a bad taste in their mouth of that particular sub who didn't put the same level of effort into the arbitration. So it would probably be very difficult to get everyone's agreement that you have both serve as this as the mediator and arbitrator. So it's a potential drawback. And then again, not it's not really appropriate where there's strong confidentiality walls that are needed in that particular case.
Right. And that's where I see a problem. You can't really unring the bell. Once the discussion on the amount of money is discussed for settlement and a mediation, then you have the arbitrator knowing where the brackets are or the baseline of where you're starting. And, it may or may not be something that would affect their ability to be perceived as giving a really good, fair, unbiased arbitrator's decision. So that's one potential drawback. I do think that there are ways to mitigate the bias, but it's really hard to explain that to your clients, and it takes a yeoman's effort to do that. The other thing is, Casey, with your situation where you have one party prepared, ready to go to mediation on this type of model, and talking about summary judgments and statute of limitations and all those issues, and the other party just showing up to see what discovery. I think it's a mediator's job to call that out, to have pre-mediation meetings and figure out who's really coming and what they're doing. And if that's the case, not to have that mediation until you come to an agreement as to at least the scope of what you're going to discuss. I know it doesn't always happen, but pre-mediation meetings to discuss your approach to these type of mediations, to make sure that it's helpful to both sides and it's not just an exercise by one side just to do discovery. That's always a mediator's goal. I know it doesn't always work, but that's the goal. Do you find that pre-mediation meetings help that, Casey?
Occasionally, you never know. Especially if you're dealing with like out of state counsel. I recently had a mediation where a very old Chicago attorney, submitted a mediation brief that was over 100 pages long. And I wouldn't say that it was not helpful to anyone because it was very factual, but it was very, very long. No one was going to sit there and read. By the way, 100-page brief is not brief. So that particular situation, we did have pre-mediation discussions with the mediator. I thought we were on the same page. We had a mediation exchange date, but again, we never talked about page limitations. But I don't know that anyone could have suspected that he was going to submit over 100-page mediation brief, which, by the way, his client ended up paying our client money anyway. So
Yeah.
I don't know how much he paid for that brief, but it wasn't helpful.
Casey, I should tell you that I do mediations both in construction and other contract cases, and it's not uncommon for me to have like 137 pages.
Oh my.
Even in complex, a tort, trip and fall situations. So I think the size of mediation briefs are going up. Um, I guess a lot of people put it in AI and summarize it. I read it, but
I bet a lot of people put it in AI to create it because there's no way that that is a concise statement of the facts that
right.
would be helpful for any party to resolve. So I guess maybe you're right. We need to have more pre-mediation meetings with a checklist of like, you shall not
Right.
submit more than 25. If you can't do a summary judgment motion that's more than a certain number of pages, you certainly shouldn't be submitting arbitrate or mediation briefs that are above a certain number of pages.
All right. So Casey, page limits. I see that's important. But on the same token, you have 100 pages of discovery. You know what they're going to do and what they're going to say, right?
Yeah. But again, it was a lot of cost and a lot of expense that we
Yeah,
could have probably gotten in a settlement if you didn't spend $50,000 preparing for that mediation.
got it. Understood. All right. Why don't we move to the next slide? So these are some practical strategies for attorneys to try to deal with this multiple venue issue. I have been in mediations where there are a lot of folks involved, bunch of parties, and I know that some of the parties haven't read their contracts because they think it's a standard form and they all say the same thing, and they don't. So especially in a case where there's multiple parties, multiple contracts, make sure you map out your contracts and the disputes clauses clearly. Know what your contract requires you to do and what it doesn't require you to do. And Casey, I'm sure that part of your practice is writing some of these contracts for large contractors.
Yeah.
Put some thought, and I'm sure because I've seen them written by some very good attorneys that have very clear dispute resolution clauses as well as attorney's fees and cost clauses and integration clauses that are all clear, ready to go. So just make sure, see what you got when you got it and look at it when it comes in the door. Identify where the conflicting tracks are. I can't tell you how often that you're in a mediation or an arbitration, and then it turns out the mechanics liens are in court, and if we don't address them or deal with them, it's a problem. So you need to identify, okay, is there an arbitration going on somewhere else? Is there a court action going on somewhere else? Are there multiple arbitrations? Talk to the other attorneys involved in the case, talk to the clients. Sometimes these clients in some of these bigger cases aren't even represented by attorneys. They represent themselves. They're mom and pop organizations. You need to figure out where they are and what they're doing. Push for coordinated mediation at project onset. Again, I'm an advocate if I haven't said it enough, where you get have a mediation or one lawyer. It doesn't have to be a mediator, or one lawyer who is coordinating the process. Where are we going to go as a group? Try to get them to go to the same venue all at once. And you can do that through mediation. Use the 1281.2 motions strategically. I know Casey, and I've heard from other attorneys that sometimes they aren't successful, but sometimes they are, and they can really help. As I indicated, the judge can outright just stay the litigation and move forward on the arbitration. And my reading of the statute, the judge can stay the arbitration and go forward with the litigation. So I think you can use the judges once you educate them on how to use this statute to best suit your case. And additionally, you have to educate your clients on the risks of uncoordinated litigation. I can't tell you how often we'll be in court and a prime will say, I want to sue the owner of the property. They didn't pay me. And then it turns around that the person not paid that was allegedly not paid ends up paying money to the property owner. So you need to educate your risks to your clients when you have litigation like this and when you have multiple venues, and they need to understand it. I'm sure, like Casey, your clients are highly educated, big companies, but there are a lot of small mom and pop litigation out there that they just don't have the ability to understand that unless they coordinate the litigation, it's going to cost them a lot of time and money.
Yeah. Well, I'll say this too. I mean, even the big clients have problems. Their contracts are not always aligned. So I totally understand that. And I'll also say I avoid transactional work like the plague. Um, I occasionally venture to that realm, but I would prefer never to write contracts or be involved in the editing of contracts. I would much prefer to just tell the contract reviewers what kind of mess they're creating and help solve the problem by fixing it in the first place. But all jokes aside, I think that there are a lot of tools these days that can help even the small mom and pops coordinate their contracts and make sure that dispute resolution provisions result in a coordinated litigation going forward should a dispute arise. There are platforms that are specifically, I have no affiliation with, that are specifically designed AI platforms where you can I know one of them is like DocuCrunch, where you can put in your contract and it can tell you what the dispute resolution provisions in, and if there's any conflicting terms in the rest of the contract that might impact your dispute resolution section of your prime contract. I mean, really, right now, technology is advancing so rapidly, and there's so many different options that I think we have less of an excuse even no matter your size, and trying to make sure your contracts are just appropriately written. And honestly, it's much cheaper to consult a construction attorney for a couple of hours than it will be to litigate a mess that occurs down the line. Just to verify that your dispute resolution provisions in your contracts are dialed to work in a coordinated fashion.
All right, next slide, please. All right, folks, this is a quick checklist, and we've talked about some of the issues before you go to the dispute resolution. Again, review all contract dispute provisions. Can you tell that's important to me? I think I've told you folks that twice. I can't tell you how many times folks are not reading the contracts. You got to read the contracts. The other thing you need to do is evaluate third-party non-signatory risks. Inevitably, on these cases, you have suppliers that are not signed or not part of any contract that are involved in this, downstream suppliers. Sometimes you have property owners, sometimes you have adjacent property owners. You have a lot of folks out there that may not be in the contract chain or in privity, but are involved in the mediation on a contract dispute that you need to get involved. Keep an eye out for them. Um, Consider adding contractual arbitration provisions to your contracts for those of you that are contract attorneys. There's many ways to write them and many ways to have dispute resolution clauses, but that's one clause you should consider adding if your clients think that that is the best way to go. And watch for common issues of law or fact. I think that one way to get more parties involved in either an arbitration or an agreement to go to court is if you show what the common issues of law and fact are. And that way they can have what I like to call a joint defense. And it's much cheaper and it works better. You have two attorneys working on one common issue of law and one common issue of fact. The more common the issues of law and fact are for these multiple party cases, the less money you're going to spend and the faster it'll settle. Casey, any experience with that?
No, but I would like to add just one kind of general overarching comment. It's if I could add one thing to this checklist, it would be that we should all treat the dispute resolution sections of our contracts, our clients' contracts, like actual, like they treat it like risk allocation, not be boilerplate. Because that's really what it is. At the end of the day, every clause you draft is a decision about where risk is going to show up later, whether, it would be timing or cost, leverage, or the forum. And in construction, we're very intentional about allocating risk everywhere else. We negotiate scope, we negotiate schedule, we negotiate indemnity down to the comma. But then when it comes to dispute resolution, it's often the last section of the contract and it gets less attention than it probably should. And the reality is that by the time a dispute arises, most of the leverage is already baked in. You're not choosing your forum, you're living with what you once agreed to. You're not coordinating parties, you're dealing with the fragmentation that was built into the contracts from day one. So the question to ask on the front end isn't just, does this clause work? It's, does this clause work with everything else on the project? Because if it doesn't, you're not just drafting a dispute resolution provision, you're drafting the blueprint for this multi-track dispute that we would hope to avoid. And we've all seen how that really plays out. So as we've talked about today, once that blueprint is in place, all you can really do is manage the inefficiency and not avoid it, which is what we don't want to have to do.
Right. And it's really important that you make sure that, I've seen the beautifully crafted primes contract, but then the contract with the sub, not with the owner, but with the sub is just something, a forethought or, we'll just throw this in. And it doesn't mirror what is between the GC and the contractor, and it causes problems. So make sure you look down the stream when you have the ability to do so.
Yeah. And even oftentimes if the general contractor has a subcontract, like have every general contractor should have their own subcontract that they use that marries the language between what they're required to do with the owner to what they're required to do with the sub. And so if you're not doing that, if you're just using your subcontracts, you're asking for a problem. You can edit it all you want, but if it's not kind of coordinated, then that's gonna always be a hiccup.
Unfortunately, Casey, in some of the cases I see more often than not, there's not even a contract.
Yeah, well, that's
Um,
another issue.
so do what you can to try to get things consistent among the parties that are going to be there, building whatever they're building or working on whatever they're working. Why don't we go to the next slide? Well, we're coming to the end of our discussion. We will have time for questions, but we just wanted to summarize that multi-track disputes are common in construction. Without coordinating efforts with the tools that we've given you and the contracts, you're going to have cost, delay, and inconsistent results. The MEAD-ARB and the 1281.2 tools offer solutions. There are many other solutions out there, contract-based, but those are the two that we decided to talk to you about today. And attorneys must proactively manage the contracts and the process. You can do it. There are many tools out there to help you. Again, as I said earlier, I'm a advocate of a process agreement. Doesn't need take a mediator, just have the attorneys agree on the process. And if you can't, you can go to mediation. But an agreement up front on the process is going to save you all time and money. As well as a little bit of heartburn. Casey, anything to add to that?
Yeah, I'd also say I think we should all reconsider. So, again, this is from my recent experience. I think we might all want to reconsider the mandatory mediation as a condition precedent to anything. We all know that mediation works the best when all the parties want to participate. If you're dragging people kicking and screaming into a mediation, the likelihood of an outcome that is positive is probably slim to none. So when we do put those provisions in our contract that require mediation as a condition precedent to arbitration per se, like for example, in my previous hypothetical, then again, you're putting yourself in a situation where I have to mediate to get to arbitration, and I may not know what I need to know to mediate. And not all parties are willing to realize that and to skip it and kind of come back to it at a later point in time. And so that's where I've seen some recent hiccups. So just keep that in mind. Again, mediation is great. I love it. I want to, proceed with mediation in almost all my cases, but some cases it's just not right for. And the other side may use it as leverage or uh, a tool for them to kind of slow your entire case down. And just be aware of that because that has happened to me recently and it'll probably happen to everyone else in this room if it hasn't already.
All right. Well, that concludes our presentation today. I understand that we have some questions. Suzanne, I think Suzanne's with us. Suzanne, can you read us those questions and we can answer them?
I'm currently actually not seeing any questions. I might take a brief moment within the Q&A. Just one moment.
I'll give people an opportunity. I have some showing up in the chat. All right, folks, we're taking a minute to see if there's any questions. And Suzanne is going to read those to you. I'm also going to look at the chat. Nothing in the chat.
Okay, so let's see. It looks like I do have a question here from our, it looks like someone's here live as well. Joel Bertet is asking, do you find that very experienced construction mediators can manage a lot of these challenges? Is it a function of the parties or a good mediator?
I think it's a combination of both. I'll ask Casey to answer, but it's a combination of both. The mediator's got to understand that there are a lot of parties, a lot of different interests, and they've, in my opinion, has got to meet with those interests before you get to the mediation and set it up and make sure everybody's ready to go. And control what's really going on. And the attorneys have to cooperate. Like I said, like Casey said, if you have an attorney who doesn't want to go to mediation and is just there just to sit there, it can throw the whole mediation off. Maybe you wait and don't even have that mediation. Understanding that I know some judges have found in Casey's example that you have to go to mediation and it's mandatory and that they're just going to sit there and not do anything. So the bottom line is it's a combination of both the lawyers and the mediators who need to work together, prepare for the mediation, and then make it work. Casey,
Yeah.
anything to add to that?
Yeah, I'll say I think I agree with you that it's a combination, and it's a combination of a good contract that would give the mediator the tools to kind of exploit with the parties, but also a function of a really good mediator. And the problem with that is, as Judge Katz probably is aware, is that we just don't have that many good construction focused mediators in Southern California. There are very few names that get tossed around again and again, and they are booked out often months in advance. And so we have found, I mean, really a difficulty in getting those good mediators on the cases that need them because those cases also can't wait for 6 months to 9 months to mediate with all the various parties, especially if it's a condition precedent to litigation or arbitration. Now, I think we have some up-and-comers and some that are just starting off in this field that are going to be great. But as with anything, it takes some experience. So I will say I agree with Judge Katz. It is a combination, but I also think we're in a very weird stage right now where we have a lot of people retiring or leaving their practice, and we just don't have people filling those holes as fast as we need them to.
Any other questions?
Yes, so it looks like we have one additional question here from Julie asking, what if arbitration clause but worried about securing damages because time for mediation arbitration will take time with multiple parties? Can 1281.1 be used for attachment?
What was that last word?
Attachment?
Okay. Not sure what Casey, you know what you're talking about, attachment. I'm not sure about the attachment, but that 1281.2, there are a lot of different, it's a pretty, wordy statute, and there are a lot of ways you can try to get the judge to assist on staying one part of any action while you deal with the other part. I don't know if that answers your question, but yes, there's basically
Yeah, I think she's talking about like securing assets for
oh, I got
eventual
it.
collection. Um, I don't believe that CCP 1281.2 can get you
An attachment.
attachment. Yeah. But
No,
it would be about coordinating the arbitration and litigation for securing your assets. You would have to proceed kind of simultaneously, but unless you could get the court obviously to stay something, right? Whether it be the arbitration or you might even be able to get an arbitrator to stay the arbitration pending outcome of the attachment proceeding in court.
sorry, I didn't understand that question. The 1281 is limited to where a party is an where there is a party that has an arbitration agreement, and at the same time is in litigation. Maybe if they're in litigation on the attachment issue, that might help, but they have to be in arbitration at the same time as litigation to give the judge jurisdiction.
Yeah, and I think you should look at 1281.8B, which I think is the provision
Attachment.
that allows you to go to court for provisional remedies, even if the dispute is subject to arbitration.
Thanks, Casey.
Yeah.
All right, Suzanne, do we have any more questions?
Yeah, it looks like we have one more question from a William Beverly. Asking, can attachment serve as a substitute for a mechanics lien?
Hmm.
I'm not an expert on attachment, but um, I, in my mind, they do two different things. Um,
Yeah, I would say I would agree with you. I don't think it's a substitute for a mechanics lien, but maybe it might be able to function similar to one when your lien rights are unavailable or impaired.
Right.
I think a mechanics lien is always going to be superior in construction. I mean, those are
Okay.
tried and true. That's a tried and true remedy, right? An attachment generally requires,
Property.
yeah, well, a contract-based claim and probable validity, where you don't
Mhm.
have that issue with, you can just record a mechanics lien. It's not,
Right.
you have to
Right.
prove that you're gonna be um, successful on your claim. It just adds a whole nother layer.
And they are both recorded. So I'm assuming attachment is recorded and mechanics liens can be recorded. Um, they go on to the next step, but hopefully that answered your question.
I do think it would be a good article. Love to read it.
Yeah. Very thoughtful. Good idea. I don't know, we're having a hard time getting the judges to understand the 1281.2 and the benefits of their ability to stay a case or join a case. I don't know if you added attachment on that, if it would cause more confusion, but it's always worth a try.
Alrighty, then it looks like that's it for questions today. Judge Katz and Casey, do you have any other closing remarks as we end the program today?
I'd just like to thank everybody for listening in and participating today. And I'd like to thank Casey. She is very wise on this area. And while we don't always agree, we agree to disagree and move on to mediate more cases or arbitrate. Thank you, everybody.
Thank you, everybody.